Okay, so just very quickly here, appointed counsel for low-income tenants. So there is a right to counsel in Washington State. So if you bring a tenant into court on the first show cause hearing, that first show cause hearing really is just going to be an opportunity to see whether or not the tenant is entitled to appointed counsel. So, well, if you had told me 10 years ago the Supreme Court was going to get involved in eviction actions, I would have said no way, but that has in fact happened. So under SPR 98.24, um, they have provided that if a tenant appears without an attorney, then the judge or commissioner has to advise the tenant of their right, a statutory right to be represented by counsel. Okay, and that the case be continued for a reasonable amount of time so that counsel can be obtained. And also in RCW, court must appoint an attorney for an indigent tenant in an unlawfully detained proceeding. So you go to show cause hearing, case gets called. If the tenant is present, okay, in Pierce County, Housing Justice Project has folks there on Zoom and on site that will then screen them to see if they're available as far as rising to the level of indigency as provided under 15 and 18640, but also under the Supreme Court ruling that they're entitled to representation. So what typically happens is 99% of the time they're going to pass screening and they're going to be able to have counsel appointed. And so the court will continue to show cause hearing. In Pierce County, it's typically it's typically about 30 days out. So what happens during that 30 days from the landlord's perspective? Not a lot. So you're just waiting for that second hearing date. And at that second hearing date, the expectation of the court, which is told to the tenant, is that you're going to have an opportunity to meet with counsel and you're going to be ready and prepared to defend this case. So it is very rare in Pierce County that a case gets continued beyond the second show cause hearing, absent some other issue arising in the case. Other counties, that is not the case. You get the continuance, and the attorney does not get appointed until a couple of days before the hearing, and another continuance gets asked for and granted. But in Pierce County, typically at the second show cause hearing, counsel is going to be appointed, and you are, as a landlord, going to need to be ready to go. Okay. All right. So some of the common tenant defenses that you might see at show cause hearing. One, as we talked about before, that the tenant has moved out prior to service or filing of the case, and or the tenant has moved out after her service or filing, but before trial. Or the tenant has moved out after service or filing, but is not asserting a right to possession. Okay, so possession is no longer at issue, then the show cause mechanism kind of implodes, and the case stops there as far as the possession issue. As stated before, you can convert it to a civil action to pursue any back due rent or damages. The tenant can state that they're still asserting a possessory right and allow the issuance of writ of restitution. But if they have offsets, for example, if you're saying they owe $1,000 a month rent that they didn't pay for 5 months, and they're saying, yes, we agree we didn't pay for 5 months, but I didn't have working hot water and my bathtub flooded, and so I only had use of half my space, so I don't owe $1,000 worth of rent. I'm entitled to an offset. That issue can go forward to trial. But the issue of possession is over, and that would no longer be an issue to be resolved by the court. Tenancy as well, at will, and someone had talked about squatters. This basically is when you use an ejectment action. If someone is occupying the property, it can be with or without the consent of the owner, but as far as tenancy at will, it's with the consent of an owner. There's no monthly or periodic rent. This is a type of relationship that the person must be ejected. That's under RCW 7.28. And does not come under the Unlawful Detainer Act under 5912 or the Residential Landlord Tenant Act. So where this comes into play, I'm sorry, as a defense is if you have, let's say, a family member who's moved into a property owned by the landlord, okay, and there's never been any type of rental agreement or anything like that, and then you serve them with an eviction action, right? They're going to come and say, well, you can't evict me because I'm not a tenant. You need to use another method, and that would be the ejectment action. So that's how that situation arises as a defense. UD must be prosecuted by real party and interest. This is a type of defense that has come up, I'd say within, I don't know, last 18 months or so, where you used to have property managers, because by definition, right, a landlord can be an agent of the owner, um, but the courts want to see the owner of the property listed as a plaintiff in the action. And so when that happens, typically what happens is the case doesn't get dismissed, but the landlord is granted leave to amend the complaint, to amend the caption, to include the party of interest, which is the owner of the property, as a party plaintiff. And then just another note here, if that party plaintiff is a corporation or an LLC, must be represented by an attorney. So if you own a property and it's the name of if you own a house and it's the name of your LLC, and then you go to start an eviction action and you're the owner and sole member, and you're not an attorney, you're not going to be able to proceed with your eviction action. You're going to need to hire an attorney to do that, to represent your LLC or your corporation for you. All right, still notices, RCW 59.18.190. Interesting statute. This thing's been on the books since 2010, and it's not until, I want to say in the last maybe 3 years that this has kind of become a major procedural hurdle in making sure eviction actions are processed. So if you look at 59.18.190, it provides that the landlord must commence their action within 60 days of the notice. Now, what does that mean? Well, and they're under the Canley case, okay, the definition of remedy was identified in an interesting way. And under the case of Canley, they stated that for a landlord to pursue the remedy, the case has to be filed, which is very counter to the way that typical eviction practice proceeds. Normally with eviction actions, we pocket serve. We served an unfiled summons and complaint because in the majority of the cases, the tenant pays. And so that way we're not out of filing fee. Well, that way the client isn't out of filing fee. So what Canley stated, though, essentially, the way it's being interpreted is that service is not enough and that the case must be filed in order to satisfy 59.18.190. All right, so when does that 60 days start? Again, that's also up to interpretation. So in Pierce County, the fuse on that starts once the notice has expired. So if you have a 30-day notice to pay rent or vacate, you serve the notice. 30 days later, the notice expires. Tenant has not complied. Then you've got 60 days after that expiration date to file your action. Okay, not the case in all jurisdictions. So some jurisdictions equate the 60-day start time with the date that the notice is served. And so if you're serving a 30-day notice to pay rent or vacate, and this is not the case in Pierce County, but in other jurisdictions, that 60-day clock starts when that notice is served. So if you've served a 30-day, the first 30 days of that 60-day period has already been eaten up. And so you only have 30 days to get your case filed under 59.18.190. So keep an eye on that. But even so, if you're the 60 days after the notice has expired, still can come up fairly quickly. So just make sure that you get those cases filed right away, and don't get lost in the fact that you may have already served the tenant. That's not going to save you from 59.18.190. Okay, so if there's been a waiver, and so this comes to or as far as again on a para vacate, has there been a waiver if you've accepted partial payment, if you served another notice, these types of things. Partial payments, Pierce County follows the case law that if a landlord accepts a partial payment that does not satisfy the total on the face of the notice, okay, that a landlord can still proceed on that notice to an eviction action. So if you have, for example, a pair of vacate notice that has February rent on it, and the tenant comes and pays half that rent, regardless of when they make the payment, you can still continue on that notice based upon the unpaid balance for an eviction action. All right. But if, let's say it is March, okay, and you filed your action and I'm sorry, you haven't filed your action. It's March, you haven't filed your action yet, but they've come in and they've paid all the February rent due on that February notice, okay? You've taken that money, but you're saying, well, you still owe March, even though that March rent isn't indicated on the notice, and you want to go forward with your eviction action based upon the March rent, you are not going to be able to do that, okay? The case law doesn't support that because they have paid off the face of the notice. And so that would be deemed a waiver that you're going to proceed on that notice for the March rent. Do we have a question?
We do have a question.
Okay, let's hear it.
If a 90-day notice to sale is served concurrently with a 14-day to pay or vacate and tenant fails to move or comply, is the ejection process appropriate or does the landlord have to go through an eviction process?
Okay, so both of those notice, a 14-day pair vacate notice or a 90-day notice of intent to sell, those are both eviction notices. If you serve them concurrently, you're golden. You're not going to have any issues, particularly in Pierce County, about one notice eviscerating the effectiveness of the other. But if you're using either of those notices, you're looking at proceeding with an eviction action, not an ejectment action. So I hope that answers the question, and you can proceed on the 14-day if they don't comply right away after the statutory time period has passed for proceeding on that notice. Okay, so I hope that answers questions regarding waiver on partial payment of rent issues. Let's see. All right, failure to accommodate. So if you get an accommodation letter from a tenant, you've got to be careful also, landlords, on this because it doesn't have to be a written notice that broadly across the top says request for a reasonable accommodation. Okay. Um, if a tenant comes to you and it can be in writing, can be verbal, that they need an accommodation based upon their disability, the landlord is obligated to respond to that. And so don't dismiss it, even if it's just something that's happening in a conversation on the front doorsteps. If they're asking for it, you need to address it one way or another and address it fairly quickly. Even if it is that you can't accommodate them, at least they know. If you ignore it and you don't accommodate them and they come back to court later and say, well, I couldn't comply with the notice because I had this issue and I explained it to the landlord, that's going to make for a fairly strong defense as far as you not being able to proceed on the eviction action and forcing you to uh, accommodate whatever need they may have. And if you don't accommodate and you've got a HUD property or something where you're getting some type of federal rental assistance on behalf of your tenant, you may be opening more of a can of worms there than you bargained for as well, right? Because you're obligated to address those concerns timely. And so if you don't, you might be looking at more than just having your case delayed or dismissed. AG's office might be coming to talk to you. Okay, income discrimination. Um, you have protected source of income, federal, state, local public benefits, rent subsidies, and emergency rental assistance. Um, you've got to be careful if you have a tenant who has another source of income saying, hey, this person can pay the rent. You know, as a landlord, do I have to accept the rent from the parents of my adult tenants if they're able to pay? Short answer to that is yes, but you should make sure that they sign off on a receipt or something to the fact that the rent is being accepted. However, that by doing so, that the landlord is not creating any type of supplemental relationship with them, meaning that they're not becoming a tenant just because you're accepting their rent payment on behalf of another. Habitability issues. Again, habitability is more of an affirmative defense. I haven't come across a situation where, regardless of how bad a shape the place is in, that it would constitute a constructive eviction. Meaning, if the person can be in the premises and is staying there, they got a roof over their heads, that there's some value to that, although it may not be much. So the habitability issue, I think, typically is going to be an issue that will be referred to trial for determining the rent amount that is owed and the offset for that rent amount, um, but not so much as a complete offense. So if anyone out there has seen habitability be raised as a complete offense and had a case dismissed because the place just was not habitable at all, I'd be interested in hearing about it. Okay, and again, talking about whether premises were totally or partially uninhabitable. Again, I've never seen incidents where it's been totally uninhabitable. Okay, reinstatement. So we talked about this 59-18-410. And so anytime before the sheriff shows up and evicts, removes the tenant, a tenant can come to court, ask the court to stay the eviction and give them an opportunity to pay everything current. What's everything? That's going to be the back rent due knowing, basically the judgment that was previously entered, if it was entered, which would include attorney fees and costs. Um, and then whatever rent may have accrued since then would be included in this repayment plan and the rent going forward. And that's broken up typically in three separate payment dates. So the monthly rent going forward is due on the date that it's due during the lease. So you've got to keep the rent current. And then that rent balance that's accrued is typically broken up into three payments with 1/3 due every 30 days. If the tenant comes to court and can provide that and convince the judge that yes, they may not have it all right now, but they can pay it all within that 90-day period, then the court is going to be inclined to sign that repayment plan. Also, if they have a pledge letter from rental assistance, that will, if they show up with a pledge letter for rental assistance that says, yes, we are willing and able to pay all of the arrearages and bring the tenant current, even though the money isn't available right then and there, if they have a pledge letter that states that, then court action can be suspended for 14 days at that point in time. I'm sorry, that's a little bit out of order because that's just court action. If the writ has already been issued, the court may not stay after that has happened. But as far as the 410 agreement, they will stay to give the tenant an opportunity to bring themselves whole. And so be wary of that. I've had many times where it's been the day before the eviction, physical eviction, where the tenant has come into court and has come up with a repayment plan. It doesn't always fly, but it does more often than not.
Question.
Okay. Yes.
If you plan to sell and notice has been made to tenant, is landlord obligated to make reasonable accommodation?
I'm sorry, state that one more time.
If you plan to sell and notice has been given to tenant, is landlord obligated to make reasonable obligation?
So, all right. So that's a great question. So in my mind, the way that the case law and statutes read is that the landlord, the reasonable obligation, um, I'm sorry, reasonable accommodation can't do anything that's going to financially prejudice the landlord. So if it's going to be the situation where if you're selling the home and you haven't been paid rent and you've got a mortgage to cover and you don't want them to foreclose, you're being prejudiced by the tenant being stayed in there, and you're being prejudiced by their request for a reasonable accommodation to extend their stay. Um, my argument would be that that's going to unduly prejudice the landlord, and the tenant is not entitled to that reasonable accommodation. It's going to be done on a case-by-case basis, though. So the court, whomever you're in front of is going to ultimately make that decision. But that's essentially what you're working with as a baseline from the landlord's perspective. Does it financially prejudice the landlord in some fashion? And if it does, then the accommodation should not be granted. Okay, I think we're kind of in the home stretch here. We didn't get a chance to go through the Tacoma factors too much. Order of limited dissemination can be asked for at any time. That's just based on a good cause, whether or not the tenant is going to uh, have a chance of prejudicing their future landlord in the same manner of their current landlord. If that is not the case, that's typically going to be enough to convince a judge to sign an order for a limited dissemination. So, great example, job loss, failed to pay rent, got evicted for non-payment of rent. Now they've got a new job, probably not going to not pay rent for, to their new landlord. OLD probably will get issued. All right, City of Tacoma, we're almost at closing here. I just want to go through this just very quickly. So, um, this link here, please go to this if you're a landlord, landlord resources page. It's a great page. You need to go there. When you do an eviction in the City of Tacoma, okay, any eviction notice has to have a notices of resources, okay? If you go to this link, you'll see them. In my paperwork on page 39 through 42, you'll see Tacoma notice of resources. That notice of resources in the packet is only for non-payment of rent notices, okay? So be aware of that. If you're evicting for some other reason, you need to go to this website here and get the proper notice of resources to go for that particular eviction. All right. So if you're evicting someone who lives in Tacoma and they have federal aid, right? They're Section 8, you're going to serve them with a 30-day notice of appear under vacate, um, valid disclosures, and these Tacoma notice of resource disclosures all attached to your appear vacate notice. All right. A lot of paperwork. Take a look here. All right, you need to have a business license in effect at the start of your eviction action. So in City of Tacoma, you need to have a residential rental business license. Get that first. You can't get it later to make up for it. Get that first and go to the Landlord Resources website to look at the links for that. Once you have your business license, then you can issue your eviction notice. Let's take a look. Oh, yeah, and also you've got to comply with the tenant protection laws. These are defenses, and they're listed here. But basically, if your property is not code compliant, that's going to be a defense against your eviction action later. So if you have any outstanding code issues, um, you're going to have a problem if you proceed on the eviction action without remedying those first. Tacoma is known for its eviction moratorium, school year evictions, basically anytime during the school year. If a tenant is a child or a student, and it says child or student, you have to be wary of that, not a child of school age. So a child of any age or student, um, uh, or if the tenant has legal custody of a child or student or is an educator, they're going to be entitled to the school year moratorium, which means that they can't be evicted during the school year, typically September 1 through mid-June. So you go ahead and get your eviction order. Sheriff just can't do anything about it during the school year. And then we have the same thing, the cold weather moratorium, November 15th through March 15th. That applies across the board. There are some exemptions under 11065. Take a look at that. If you are exempt from the school year cold weather evictions, then you get your writ and you're off business as usual. Okay, well, 2 minutes over. Sorry, guys, there's a lot of information and not a lot of time. I invite you to contact me directly if you have any further questions. Uh, oh, I don't have my email there, but if you let Amy know, she can get that to you. It was a pleasure talking with everyone today, and hopefully there are more answers and questions today.